Today we will learn about Indian Contract Act 1872, the main law that sets rules for forming, performing and enforcing contracts in India. Have you ever wondered why some promises are legally binding while others are not? Like buying a phone versus a casual promise to meet a friend. The act was enacted on 25th April 1872 and came into force on 1st September 1872, providing a clear legal framework for contracts. A contract under Section 2H means an agreement enforceable by law. So the courts can make parties keep certain promises when needed. Agreement forms when one person makes an offer and another shows acceptance. So remember, agreement equals offer plus acceptance as the basic formula. An offer under Section 2A is a clear proposal communicated to another, and it can be expressed or implied, unilateral or bilateral. Acceptance under Section 2B must be absolute, unconditional, and communicated in the prescribed or a reasonable way, with postal and receipt rules applying. The Act lists essential elements under Section 10. So parties must have intention to create legal relations, lawful consideration, capacity, free consent, and lawful object. Intention to create legal relations matters. Social or domestic promises often lack it, as seen in the case of Balfour versus Balfour. Consideration under Section 2D is something given in return for a promise, and it may be past, present, or future, yet must be lawful. Cases like Curry versus Misa and Chinnaya versus Ramaya show consideration can be a benefit or detriment and may move from a third party. Capacity to contract under Section 11 requires majority, sound mind, and no statutory disqualification. Minors and persons of unsound mind lack competence. Free consent under Section 13 means agreement must be voluntary or the contract risks being voidable or void depending on the defect. Vitiating factors include coercion and undue influence, which make consent unreliable, and contracts affected by them are generally voidable at the victim's option. Fraud and misrepresentation also vitiate consent. Fraud involves intentional deception, while misrepresentation may be innocent, both often making the contract voidable. Mistake of fact can be fatal when mutual and about a fundamental fact, rendering the contract void, unlike most unilateral mistakes. The object and consideration must be lawful under Section 23, and contracts against public policy, morality, or the law are void. Some contracts are expressly void. For example, those restraining marriage, trade, legal proceedings, or which are wagering agreements, as the Act explains. Terms must be certain and performance possible under Sections 29 to 36. Otherwise, the agreement cannot be enforced as a contract. An offer can end by revocation, rejection, or lapse of time, or by the death or insanity of the offerer or offeree in many cases. Carlyle v. Carbolic Smokeball Company illustrates a unilateral offer accepted by performance, and that clear intention to be bound can make such promises enforceable. The doctrine of privity means only parties to a contract can sue or be sued, though exceptions include beneficiaries under trusts and certain assignments. A valid contract satisfies Section 10 elements like free consent, lawful consideration, lawful object, competent parties, and intention to create legal relations. A void contract may be unenforceable later, for instance by supervening impossibility, while a voidable contract remains valid until the aggrieved party rescinds it. An unenforceable contract is valid in substance but blocked by technical defects like lack of required writing, and an illegal contract is void from the start. Performance under Section 37 onward means parties must fulfill promises. Typically, the promisor or their authorized agent must perform the obligation. Performance may be actual or tendered. A proper tender can discharge the promisor if the promisee wrongfully refuses to accept performance. A contract is discharged by performance. Agreements such as novation or rescission, impossibility or frustration, breach, operation of law, or lapse of time. Section 55 makes time essential when agreed. So delay can allow rescission if timely performance was the contract's purpose. Otherwise, compensation may be due. Breach includes actual failure and anticipatory breach, where one party refuses beforehand, and an aggrieved party may terminate or seek remedies immediately or later. Remedies include damages, specific performance, injunctions, restitution, and quantum meruit to compensate for work done when full performance is impossible. Damages under Section 73 aim to compensate actual loss, with rules from Hadley v. Baxendale limiting recovery to foreseeable losses and requiring mitigation. Specific performance may be ordered for unique goods or property when damages are inadequate, while injunctions can restrain wrongful acts like breach of negative covenants. Restitution under Section 65 restores benefits when contracts are void or rescinded to prevent unjust enrichment, and quantum meruit awards reasonable payment for partial work. Section 74 controls liquidated sums on breach, and Fateh Chand shows courts award reasonable compensation, not unconscionable penalties, even if a larger sum was stipulated. Quasi-contracts in Section 68 to 72 are obligations imposed by law to avoid unjust enrichment. For example, supply of necessaries to a person unable to contract. Examples of quasi-contracts include payment by an interested person, non-gratuitous acts, the finder of goods, and repayment of money paid by mistake. Contingent contracts under Sections 31 to 36 depend on future events collateral to the contract and are enforceable only when the contingency occurs or fails. Contingent contracts fail if the event is impossible, and they are not wagering agreements because wagering lacks enforceable obligation or interest in the event's outcome. Indemnity under Section 124 is a promise to compensate for loss, common in insurance, while the indemnifier must meet losses caused as agreed in contract. A guarantee under Section 126 involves principal debtor, creditor, and surety, with the surety having rights of subrogation, indemnity, and contribution from co-sureties. Bailment involves delivery for a purpose, with duties on bailer and bailee to take care, while pledge is bailment for security, letting the pawnee retain or sell on notice. 182 to 238 lets an agent act for a principal, creating binding effects when within authority, and ends by death or revocation. So what do we learn from this act? In simple terms, it gives clear rules for making contracts, sets duties, and provides remedies when promises are broken. Let us quickly remember the main points: offer and acceptance, consideration, capacity, free consent, lawful object, performance, discharge, breach, and remedies for fairness. Thank you for listening. Keep exploring contract law gently, and if you want more structured notes and practice, feel free to explore related material on EduRev.